we are going to unpack and explore human behavior. And human behavior is fascinating. We're going to look at trauma, victimology, and I'm going to use all of my expertise over the last 25 years to really give you the gift of understanding human behavior and the fascination we've got with psychopathology, crime, victimology, criminal justice, mental health, forensics and statutory cases. And with that, I will, on my own and with the assistance of some of my guest speakers, really give you insight in what the human factor means in our lives and our daily existence. Judge Wille, welcome to the Human Factor. We're here today to discuss a judgment made by yourself, and I want to take you through the judgment just that you can give our listeners an explanation on how does this Rule 43 application and how does it work to give interim relief to people in these kind of court proceedings.
So good evening to you and good morning from South Africa. Thank you for having me on your podcast. Interim financial applications are used to give a party interim financial relief pending the outcome of a divorce. Where this case was a bit different and where I interpreted the legislation a bit differently was that in South Africa we follow what is called an adversarial approach, which is the applicant files an affidavit, the respondent files an affidavit, and the court is then basically bound by what is set out in those affidavits. There has been a tendency, there is a rule 43.5, that allows in some circumstances on application for a further affidavit to be filed. Where this judgment was a bit different was that because there were minor children involved and because the application that came before me was a reduction of the interim financial relief that was given. And in the reduction application, there were certain allegations about the fact that the person who had to make the monthly payments had been sequestrated. And this affected the minor children in that the house, the matrimonial home, was going to be sold and the children would suffer. So there was a provision in the rules saying that the court can take into account what is in the best interests of the children, and the court could come to a just and equitable decision. So I reasoned that in order to come to a just and equitable decision, where there are minor children involved and where the financial reduction would affect the minor children, the court could get involved. In other words, no longer an adversarial approach, an inquisitorial approach. The court could make inquiries and order a person to come and give evidence and for the production of certain financial documents. So other than the normal adversarial approach, I said that in these circumstances, where there are minor children affected, where there are finances involved, the court can get involved and not just leave it up to the litigants and the court remain a neutral umpire. So that really was the nub of the judgment.
Judge Wille, and in this judgment, how would you say the court got involved that is different than a usual adversarial process to serve the interests of the children?
Well, in this case, the person who had launched the application for reduction in the interim financial relief, he had been sequestrated by his brother and they were in business together. I then got involved by saying his brother must come and give evidence. I want to hear from his brother, and his brother must come and produce financial documents to show that this sequestration application was a genuine application and wasn't brought for the purposes of merely circumventing the provisions of the interim financial relief order. I asked the brother to come and give evidence. Initially, it seemed as though he agreed, and then later got legal representation and may have changed his mind. And that is what the case is about.
And what happened at the end? Did the brother come to the court and give evidence?
That step has not yet taken place, but the judgment has been delivered, and his application to be excused from the court and not to give the documents has been dismissed.
Right. Judge Wille, and in this situation where there is complex financial sort of disputes between parties that separate, where children are being affected, how is the best interest of the children determined?
Well, you see, traditionally, that's the number of, I'm glad you asked me that question. Traditionally, in our jurisprudence, the best interests of the children was solely really confined to issues such as care and contact and other issues of which you are an expert. It didn't really also include financial distress or financial difficulties. And I reason that the best interests of the children is a holistic approach, including if there is severe financial distress to the children or trauma, or, I mean, if I reason that if a child, for example, if the mother was left destitute and had to be kicked out of the matrimonial home with her two children, it would have an effect on the children. I reason that financial distress was also something which the court must take into account when considering this concept of what is in the best interest of children.
Judge Wille, and I think it is a refreshing approach to looking at the best interests of the child or children, because obviously children are affected by the financial disputes between the parents, and often it would lead to children being affected either by they have to move schools or they lose their home. They should move. Often you see children moving from one home to another because of financial distress. So it is definitely something to consider, I would say always, from a holistic perspective, to look at what is in the best interest of the children when it comes to financial disputes between parents and the parties, obviously, that is in conflict. Does that happen frequently where this holistic approach is being adopted? Because obviously in some of these cases that I've been involved in as an expert, it's not, I haven't often seen that is being considered as an aspect of determining the best interests of the children.
Well, the concept of the best interests of the children and the leaning towards an inquisitorial approach has been adopted by our previous Chief Justice, Judge Howie, when it comes to the best interests of the children. But that did not extend to the financial implications of a reduction in maintenance or hardship financially by one of the parties. And I reasoned that the best interests of children included this. So this is the first sort of judgment where a court has come to the conclusion that the best interests of children also includes financial hardship or distress. And hopefully I was correct in my reasoning.
Yes, and I think that is quite a milestone that really serves the interests of children. Judge Wille, if you look at, obviously when people go through a court process, they don't understand the law if they're not, have got a legal background. Can you, in short, just explain what is an adversarial and what is when you do more of an inquiry, just the difference between that in layman, just normal terms that people can understand what that means?
So an adversarial approach is really where the two parties, via their advocates or attorneys, present to the court their various arguments, and the court really can't get involved and ask questions that go outside what is before the court. So in other words, the issues that are before the court that are raised on the affidavits, that is what the court must come to a decision on. And the court sits as a neutral umpire, listens to the arguments presented by both sides, and then makes a determination in accordance with the law and the facts that have been placed before the judge. Contrary to that, is an inquisitorial approach where the court can say, I want to hear certain evidence, or I want certain documents to be produced, and the court is then no longer an independent umpire. The court then really gets involved to get to, as one of the authors said, to get to the bottom of the matter. The court then invokes certain powers, and Rule 43.5, which is a sub-rule to Rule 43, says that a court can call for evidence which it deems necessary so that it can make a just and expeditious decision. And that gave me the avenue of being able to use this sub-rule in order to invoke a more inquisitorial approach.
Right.
So in some European jurisdictions, I'm not sure exactly which ones, but they have more of an inquisitorial approach where the judge takes an active role in investigating, for example, a crime, or investigating an issue that comes before it, whereas in South Africa, we have more a strict adversarial approach.
And do you have an opinion on is there different approaches that serves a specific case better?
I think when it comes to children and family law, my view, I may be wrong, but when it comes to family law and children, I think an inquisitorial approach would be a better approach. I think there is an obligation on judicial officers when it comes to family law, and I would hope for further developments in this connection, that courts get more involved, that there's more, for example, that there would be more specialization, that one would get family courts, and that the judges who sit on these family courts are trained, maybe by professional psychiatrists and forensic investigators like you are, to actually understand more what is before them and to get more involved. Mm-hmm. But at the moment, that is not the position. But I certainly hope going forward that judges who sit in these family courts would be trained like experts mm-hmm. like yourself, to be able to give the judges more information, more insight. And as you said, as your podcast highlights, in these circumstances, there should be more of a human factor mm-hmm. involved with judges. That's what I believe. Whether or not we'll get there, I'm not sure.
I think, and that's obviously my hope as well, is it would be nice if we can get there, because people that go through the court process, and especially in family law matters, but I guess in all matters, it can get very emotional and heightened, and especially where children are involved. And the court is quite a daunting process for normal people to go and sit in, and to go through that process can be very distressing. And obviously there's another layer of that when children are involved. It's even more distressing for people. And I do think it is significant for everyone that is involved, all role players that is involved in the court process, to understand, but we are just working with humans. There's human error, but there's also a lot of, we have to look through a humanistic lens at people to understand their problems and what they are going through, because it's not easy for people to go through the court process. When I read your judgment on this specific case, what did stand out to me is the wording of a holistic approach. And I do think if people and professionals start working sort of more integratively with a holistic view, it can be really helpful that people see we're actually working with humans. I do even think in a forensic capacity, when, families are assessed, often it is very theoretical, and there's a place for that, but we mustn't forget that we are working with real people, and people's lives are in, experts' hands and in the court's hands, and we have to be very careful with the decisions and the assistance that we provide the court with, because it really has an impact long-term on vulnerable people that is sitting in the courtroom. Is that something that you think of at times or all the time working with people in your courtroom? That it is the humans?
When you become a judge in South Africa, you have to swear that you will uphold the Constitution. And I don't take myself seriously, but I take my job very seriously. And we have a very good Constitution. Section 28 of the Constitution says that a court has to take into account in any matter a primary consideration of what is in the best interests of children. And I take that very seriously.
Yes.
We have an excellent Children's Act, which you've worked with before many times, I'm sure. So the foundations are there in our Constitution and in our legislation to move to a system where I believe there's a more inquisitorial role to be played by judges, where the human factor comes into consideration, and where experts such as yourself feel that they can make a serious contribution towards assisting either the settlement of a case or the correct decision in the outcome of a case. Mm-hmm. And as I say, we have the foundations. It's a question of developing the law. And in our Constitution, High Court judges do have the inherent power to regulate their process, and they are obliged to develop the common law in line with the Constitution. And that's what I attempted to do in this judgment.
And I must say, Judge Wille, that, for me that has been a practitioner in South Africa for many years and that has moved over to Australia, is South Africa has got definitely the Constitution, and the Children's Act is incredible for serving everyone's interests. And we've seen in Australia as well now an amendment to the Family Law Act that I would say looks very similar now to the Children's Act in South Africa, that gives children a voice, that looks at their best interests. And I think that was really good to see in the Australian context. And I thought to myself, this is very much in line actually where we sat in South Africa with our Children's Act. And it is good that Australia has adopted quite a strong emphasis on what is in the best interests of children, that we don't just globally pay lip service to what is in the best interests of children, but that we really do the work to implement and to serve, obviously, the vulnerable society of our children and what happens to children through following the law and implementing it effectively.
No, the voice of the child is a very important concept and concern. And although not appropriate in this case, maybe in other cases, I can't see why, in principle, as a general proposition, why in a Rule 43 reduction application where possibly the family were being, because of the financial implications, had to leave their family home because one or other spouse didn't want to pay interim financial maintenance. I can't see any bar in principle for a judge applying the correct principles in terms of Rule 43.5 to ask the child to come and see the judge in chambers and ask the child, well, what do you think about leaving your family home and going to live with your cousins in a different town because of these financial implications? What do you feel about it?
Yes.
I think that is important. I didn't go far in this matter because it wasn't necessary, but I don't see generally why there can be any objection to that.
Judge Wille, if we look at cases, just sort of stepping a little bit away from this judgment, but also obviously there were children involved in this case, but I have not often seen judges calling children into chambers and talking, as what you've now suggested, to the children directly and hearing their views. And I've been in a case in Cape Town where a judge decided to do that, and I thought it was an incredible position to take in, to actually bring the children to court, that they can sit with the judge and explain their views. And it was little children, And I think it was it pushed the matter forwards to actually hear that the judge hears from the children what their views are, that it doesn't get lost in translation, perhaps even through talking to an expert like me or any other professional, but that the judge actually sat with the children. How often has that happened where you've asked for the children to sit with you in chambers and hear directly from them?
I haven't invoked that yet in a matter, but I've given it a lot of thought. And I think it's a very good idea, subject to what I would say would be the necessary safeguards. Firstly, I wouldn't allow either the husband or the wife or the father or the mother to come into chambers with the child. I don't think that would be fair on the child. Secondly, I would ask the experts on both sides, if there were experts on both sides, for example, if you were an expert on one side and there was a colleague of yours on the other side, I would ask both those experts to attend in my chambers when I interviewed the child and asked them a few relevant questions. Alternatively, if there was only one expert available, I would then, in South Africa, we have the offices of a family advocate who always file reports in this matters. It's mandatory. I would then ask the representative from the office of the family advocate to sit with me in chambers while I ask the various questions to the minor children. I think there must be safeguards in place. I don't think, personally, I may be wrong. You would be much more qualified than I am on this aspect, but I don't think it would be, I don't want to use the word fair, but it would probably maybe a bit distressing for a young child, particularly if, you're dressed in robes and the person comes into your chambers where there are hosts of law books and so on. It's not really an environment where a child maybe doesn't have support will feel comfortable. And
Yes.
I think that level of comfort must be present if you're going to ask the child directly about his or her views. So those are the safeguards I would build in.
Yes, and I would agree with you. Do you think then that potentially, and we're talking about perhaps a wish list and a bit of a fairy godmother kind of approach to this, but do you think in future a courtroom or chambers should be more child-friendly, where there is the specific safeguards for children to actually feel that it's easier for them and it's a bit more of a safe and approachable environment, something that they don't have to feel scared of, where they actually feel, it is a place where they can come and bring their voice or their views to be heard. Because as you say, when I speak to children, often children are scared of judges. They are scared of the courtroom, and it is quite daunting. Is it not? Does the onus not rest on us then as professionals to think forwards of how can we sort of make the court look different, or where the children actually feel that the court is a friendly place, it's not a scary place?
Yes, I think that blends into the hope that I have in the specialization of family courts. I think that's very, very important. I believe in our division in Gauteng, in Johannesburg, there is now a specialized family court. And I speak under correction, I think it's manned permanently by 2 judges, very experienced. And I understand that a very experienced family lawyer has recently been acting in that division. And that is something which encourages me. I really believe that family law litigation, and particularly where minor children are involved, that courts should be more specialized. And as you say, there should be more involvement with experts, more mediation, an environment that is more friendly, less adversarial, and more inquisitorial, but in a less formalistic approach to be adopted. If the parties are fighting only about money and it's a monetary issue and it's a commercial divorce, as we call it, the commercial divorce, well, maybe that's different.
Yes.
But with minor children involved, and there's the human factor, as you say, involved, I think specialized courts are a very, very good idea.
And I do think we need to think a little bit forwards of how should we serve the interests of children. We're definitely moving in the right way. And that's why I really love the approach of a holistic approach to look, a child is multifaceted. It's about an emotional experience. It's about a child's right to education, but obviously also the financial aspect to children should be considered. But we need to think forwards of how do we bring all of those sort of areas and facets of a child together to really serve their interests in a friendly and safe way that they feel heard. Because what I definitely see with children, they don't feel heard. In criminal proceedings, in family law proceedings, often children sit with me and they don't feel that they're actually being heard. Even after they've gone through the interviews with the expert, or they've got a children's lawyer that represents them, they often feel misunderstood and that they don't feel that they have got a voice, even if that is what we are trying to do, to look at their best interests. That is not necessarily how the children feel going through these processes. And for children, the ones that have gone to court, they definitely don't see it as a place where they have got a place to speak up. We are not creating an environment that is child-friendly or that the child feels that they can go and sit and really feel heard and safe with their views. And I do think we've got a long way still to go to meet the children's needs. And obviously, where children are involved in litigation or in the law, we actually should meet the children where they are at. They should not meet us where we are at in a legal proceeding or in a court process. We have to look at them and their needs going forwards.
Yes, I agree with that. And I also think, people should also consider judges, and I only speak for myself, not my colleagues, but, for me, it's much easier to sit in a commercial dispute and to write a judgment. The judgments that make me consider things anxiously and that are difficult and that maybe keep me up at night and worry me are judgments where one has to make the decision about minor children. Those, for me, are the most difficult judgments to write. They are the most difficult decisions to come to. You have issues sometimes involving relocation of children where one parent decides to relocate to another country, for example, Australia, New Zealand, wherever it is. And the one parent is now, because just of the logistical factors involved, is now not going to see his or her children for a long period of time. Those are very difficult decisions. And the more experts one gets involved in issues such as that, and the more one can mediate that type of litigation, I believe the better. Judges are human. We make mistakes. We don't always know all the facts. We have to decide matters sometimes on affidavits. We don't always hear evidence, and it's incredibly difficult. And that's why, for me personally, I speak for myself, I think that a much less formalistic inquisitorial approach with experts is followed in matters involving the rights of minor children.
Judge Wille, I can't agree more. And I do think I think everyone will need to think very hard of how do we really tackle this issue, because it is something that we need to think more of, because it is difficult and people do make mistakes. I think as what judges can make mistakes, experts make mistakes. You can only see what is in front of you. and you can obviously investigate and analyze, but that does not mean that everything is perfectly correct on all of the recommendations that is even put in front of the court. And one thing that we obviously don't want to do is we don't want to make mistakes of young children's lives, because it has a huge impact on their lives going forwards. It can be detrimental to the child if we think about children where there's abuse matters. You know, we have to try and do the right thing together as experts and obviously the court. But it's very important that everyone works together and develop insight and really hear what is in front of us for the people that's going through these processes. And every case is obviously different. There can't be a template of this is how it works for this kind of case. We really have to be very mindful of knowing who is sitting in front of us and what does the kids need, what does the children need, what serves that specific family. But that often, as you say, keeps us up at night. And so it should, I guess, because we are working with people and we've got an impact in their lives going forward. So very important that we think carefully about what is in the interest of children and in families.
So I agree entirely with you. And I also agree that a more inquisitorial approach, I think, could assist to coming to the right decision. You have matters, for example, matters involving allegations of parental alienation. Now, how a judge is to decide those matters on affidavit or without, or even if there is oral evidence, but where a judge has to sit as an umpire with his hands tied behind his back, how can he, at the end of the day, unravel whether or not these allegations of parental allegation of substance or not? I believe judges should be given more power to have an inquisitorial approach to find out, to make inquiries, to call witnesses and to decide, because at the end of the day, they are deciding what is in the best interest of the child, and they have a constitutional duty to look after the best interests of the child. That's a primary consideration.
Yes.
And it's difficult to do that if you on the sidelines, if you're sitting on the bench. So it's a tricky process, a difficult process. But I think that it needs to be developed and advanced, and specialization, of course, will definitely help that cause.
Yes. But Wille, I do think with any case involving children, that's why I feel so strongly to listen to children, because children often brings a reality to these cases where they give us answers that we need, where we can look past what the parents say or even other role players. But the truth often lies in what the children say. And if it is more inquisitorial and we really listen to children and we get all of the information and we can ask a lot of questions, often we will find the truth. And that is ultimately what we want, is to start talking about the truth of what really goes on, not the manipulation or the fabrication or the false allegations. We want to sort of cut through that potentially, and it's difficult and tricky. But the more we listen, and if we listen carefully, I think we'll hear what needs to be said, especially through the children themselves, that I would say is the most important in these court proceedings, family law court proceedings, where children are involved.
I agree with you. I also think the role of social workers must not be underestimated. You do get some social workers who really are excellent at their jobs. And although matters are often referred to experts after the social workers reports, some of these reports are excellent. The social workers some of them really seem to understand exactly what the position is for want of a better word, on the ground. I think the role of social workers is very important. And social workers in South Africa are stretched. They are busy. They have many cases, but I try and always encourage social workers' reports to also be filed, because they also give you a different perspective and a different angle on what the issues may or may not be that you have to determine at the end of the day.
Just Wille, and I think if we look at from a systemic perspective, I do think that is where social workers really are well trained. They understand social systems. And they're quite practical in nature. I think social workers are drawn to social work practice and a social work degree because they're often quite hands-on practical people that understand on ground level and in the field how it works. And I do think when it comes to these kind of court cases, it's important that people know and the judges know, but how does it really look at home? How does it look in the child's world? And I think that is where social workers can really contribute to give the judges insight on what is really going on at home or at school or with the child from a very practical and solid approach, where perhaps the psychologists can give the insight more from a psychological perspective, a feelings perspective, a diagnostic perspective. And I do think it's not one or the other, it's perhaps both, because we need to be able to visualize how does this child's world look through the lens of the social worker in real life, and how does the child's mind inside look, or the family, of a diagnostic perspective that is really helpful for judges to understand the child or the family's world from perhaps a psychological, psychiatric, and social science perspective, because that will really give a judge thorough insight on how does this family look like in real life. That is very effective. So I think that is a very good point, because there is quite a lot of people frown upon social work reports. It's nearly a lesser than a psychology report, and I don't think it's one or the other. They serve different purposes.
I agree with you. And also, one must understand, although a lot of these orders that judges make or judgments that they write are interim or interlocutory orders, and people say, well, they're not final in effect, and so on. But if it takes 2 years or 2.5 years to get to trial, and an order is in place that regulates care and contact or whatever it is for a period of 2.5 years, a lot of damage can be done. A kid can suffer a lot in 2.5 years. So, in my view, everything possible must be done to ensure that the right decision is made. Whether it's interim or final, the right decision must be made. And maybe one should, if one is unsure, maybe one should make interim decisions for maybe an interim period of 6 months, and then ask the parties to come back to court again after 6 months, file further reports, see, how is the child doing? What has the effect been of the order on the child? So there are ways, if one adopts a less formalistic and more inquisitorial approach, I think there are ways to try and get the decisions to be more correct and more accurate. And that's what I certainly, as a judge, strive to do.
And I do think that is a good approach, because it's a holistic approach that looks at sort of where the child is in different stages of their life as well. Because as you say rightfully, often these interim orders creates a bit of a status quo as well, and it can be, perhaps sometimes it's not the right thing to do, but then that is just the status quo of how things are now. And if you don't check in again, and you don't consider the child's development or changes that has happened over time, damage can be done. And just because certain orders are made doesn't mean that that's the right orders or interim orders for the long term, for the 2, the 3 years while you wait for a court date. So it is important that we just think how we can really serve the community and serve the people that are going through these challenging times in their life, because it is a challenging time. It's not an easy time of a person's life.
Yes. And, our family advocates do an incredible job in South Africa, but they are under pressure. And I sometimes, when I need some input from them, instead of directing them to file a report within 30 days, I know it's possibly difficult or impossible for them to do so. I ask them to file just to file a short interim memorandum, just within a period of 30 days, to show me where their thinking is, so that I can sort of tailor an interim order for them then to be able to make a proper investigation. So there definitely are ways in which step-by-step, slowly approach can be adopted, so that at the end of the day, one can build in everything possible that you can come to a right decision at the end of the day. As you say, I think a revisiting of the children's position on on a frequent basis is probably something that can only augur well for the best interest of the child at the end of the day.
Absolutely. And I think sort of that is where we need to look at protecting children inherently. That is the most important part, is how do we serve children? How do we protect them? If we look at our statistics of gender-based violence, domestic violence, terrible things happen to people and to all people. And it's important that we look at what is the right thing to do at the right time to make sure that, that everyone works together and that they know what they're doing to assist on ground level, and to use the systems effectively to make sure that we protect our community and protect our children.
Yes, and the work that experts like you do and other experts in Cape Town, we are blessed in Cape Town to have experts, very, very intelligent people, very, very meticulous people, and we must call on those people. I don't think, there may be some views that judges may or may not feel that, well, they're interfering with the judge's preserve or the judge's rights to make a decision. I have a totally different view. I say that experts are there to help the judges. Experts are necessary. There are certain things that we as judges are not trained to do, and we must listen to experts, and we must take into account what they say. And the more advice they can give me, particularly as a judge, to coming to the right decision, I'll accept that advice. And I will never say, well, that's not the preserve of an expert to tell me what to do. I adopt a more inclusive approach when it comes to experts, because at the end of the day, it's the decision, it's the right decision that counts. It doesn't matter about whose feelings may or may not have been hurt to get to that right decision. Egos are not important. It's getting to the right decision. It's important.
And I think sort of an inclusive approach is a good approach. And I think from an expert perspective as well, experts should be neutral. I think often people feel very frightened that, is the expert going to take a side, or are they bought when, some of the experts, there's obviously money to be paid for service delivering, and that can create sort of fear. But I do think most experts, I don't want to generalize, but takes on a neutral, good, ethical, professional role to make sure that they do the right thing, the ethical thing, and to assist the court, because they're there to assist the court. So people should not be frightened to get experts involved, and people that, have studied this and have been trained to assist their families and people to assist the court and the judge with information that can be of help and can be of assistance.
Yes, it's interesting. I was giving the matter some thought the other day. For example, when judges sit on tax matters, then we are allowed to get assessors that are experts in tax. to help us to come to the right decision. Now, the decision at the end of the day when it comes to tax is about money. So money is important. But when it comes to children, the decision at the end of the day from a human factor is much more important than the decision about money. So one wonders why a judge could not ask for an expert such as yourself to sit as an assessor on a matter involving the best interest of a child. Mm. It just seems to me that we need to push for more inclusion of specialists, experts. Very often in matters, I direct that, and it's a power which a judge has, and I use it often. I direct that the experts file a joint minute. Yes. They tell me why I don't want to know why they agree. I want to know why they disagree. Mm. So they must file a minute saying, this is what we agree on, but this is why we disagree. Mm. And these are the points we disagree on. And that short, is a shortcut to the proceedings, allows experts to actually start working with each other and with the judge, work together with the judge. Then the better the decision will be at the end of the day. And what we're trying to do is to give the right decision. That the goal is to give the right decision. So the more people you can have working towards that ultimate goal, in my view, the better.
Judge Wille, and I think where things really go wrong is obviously experts can have different opinions, but experts are not there to fight with each other. They actually should work together or align to see where is there, for example, disagreements and agreements to make it work for children and for families to assist the court. But often, and I've seen it, some experts, and as you say, there's egos involved there, it becomes more about them and their opinions than what is really in the best interest of these families and children. And we need to really stay away from that kind of outlook as professionals that is there to actually assist the court and to assist these families and children. Perhaps just the last point before we end is, and this is where obviously the judgment of yours or the focus of the judgment is, I do think we should think a little bit perhaps more in monetary terms when there's children involved, because children do need financial support and assistance. And I've seen so many times where children are significantly affected by separations and where there's money for litigation and there's lots of money for litigation, but there's not money to assist children. There's not money to pay for children's extracurricular activities, or children should move schools, or there's not financial contribution. And all of that financial manipulation and financial control does not serve the interest of children. So we should really look at what is in the interest of children financially as well, to make them feel settled and secure. Obviously, they shouldn't know about what is happening necessarily financially, and it shouldn't be a discussion. But we should consider that, because it is a considering factor to look at the best interest of the children and what their needs are.
Absolutely. And children are also influenced. You could have, for example, where one would have an interim order involving split care and contact, where the child is with one party, there is poverty, and the child doesn't have a lot. And when the child spends time with the other parent, the child has everything that it desires.
Yes.
And that may factor in on the child's, at the end of the day, the child's wish of where the child would like to spend most of its time, and who would be the primary caregiver. The financial aspects are also important aspects.
Absolutely.
And I think, as you say, one has got to look at the matter more holistically than just in different separate compartments.
Yes, I would fully agree that we need, it's time that we look at things more holistically. It's interesting, but I think historically perhaps didn't have such an inclusive, holistic approach when it comes to looking at decisions around children. but we're definitely at a place where we need to look future focused on what can we do to really serve children's needs and to really look after their best interests.
I think that from your side, the human factor, it's important. Judges are human. We always try and make the right decisions. We sometimes get it wrong. We sometimes get it right. But I think that at the end of the day, the more assistance that judges can get in a less formalistic, more inquisitorial approach, where we are advised by experts and social workers, the chances of getting a decision correct are enhanced. And that's what I certainly strive for. And I hope that our law in South Africa, but also in other countries, will develop in this connection, because the interests of minor children, as you say, and as our constitution says, that's paramount. That's what cases at the end of the day are all about. It's what's in the best interests of these minor children.
And I think my last words would just be I want us to get it right. I don't want us to make mistakes with children's lives. We can't afford to put children through things that is not serving their lives and just their lives ahead. It's our responsibility and our duty to do everything possible to look at what we can do to serve children. They're vulnerable, and it's often our decisions and the court's decisions that gives them a good life or a difficult life. So very important that we look at what we can do. Everything possible is to look at what is good for them and what serves them throughout their life as children growing into healthy and well-adjusted adults. Judge Wille, thank you for joining the Human Factor. I really appreciate your time, and it was really insightful to look at how we can approach matters from a more holistic approach, to look at the human factor of children and the best interests of children in court proceedings involving children. Thank you.
Thank you very much. Appreciate your time and what you do for the interests of children. I'm very grateful for experts like you.
Thank you.